CRJ 225, this is your Week 5 podcast as we wrap up crimes against persons with a discussion of sexual assault, false imprisonment, and kidnapping. I've asked that you read the document provided for this week and the statutes referenced for this week before you listen to this podcast. If you haven't done that, go and do so. If you've done that, you know that Illinois does not use the term rape in sex crimes. What other people may consider rape, state lawmakers have termed criminal sexual assault. The intent of the legislature in discarding the term rape was to lessen the stigma attached to the crime and therefore encourage more victims to come forward and pursue the offender in court. Now, having just finished a discussion of assault and battery, we realize that what we would think of as a rape is definitely a battery, right? It's not an assault. It's not a threat. It's not a fear of harm. It's not it's an actual touching. It's an actual harm. But be that as it may, that's the background, and that's what ours is termed. As you know, it's found under 720 ILCS 5/11-1.20. The offense is categorized as a Class 1 felony with a potential of 4 to 15 years in prison. It's a non-probational felony. That means the judge is not permitted under the law to sentence an offender to probation. Prison sentence is mandatory. Consequently, the minimum penalty for criminal sexual assault is 4 years in prison. It's committed when an individual commits a penetrative sexual act against another without consent or the ability to give consent. This includes sexual acts against victims who are underage, mentally disabled, or otherwise incapable of giving consent, in addition to sexual assault through the use of or threat of force. Go back to our recently completed review of assault and battery. When an adult has sex with a minor, it's commonly referred to as statutory rape. It's considered sexual assault because the minor cannot legally give consent. So even if the minor had consented, they can't legally give that consent. Sexual assault cases frequently involve incidents that occur between two people in private. So this means there's often a lot of conflicting narratives about the acts that happened, and those conflicting narratives complicate prosecution. Now, forensic science, increased and evolving police training, and the development of sex crime units. One of our favorite shows in our house is Law and Order SVU. We've watched Olivia Benson for a lot of years now. But well-trained, and depending on the size of the department, well-trained officers with sex crime education and experience has changed this to some extent. But sexual assault and related crimes continue to present unique problems for police, for prosecutors, and defendants. Criminal sexual abuse is the only Class A misdemeanor sex crime in Illinois, and criminal sexual abuse can be either a felony or a misdemeanor depending on the circumstances. Even where the offender is found guilty of a misdemeanor, they will be required to register as a sex offender. Criminal sexual abuse is established in the Criminal Code under 720 ILCS 5/11-1.50. The statute provides that a person is guilty of a Class 4 felony where they commit sexual conduct in conjunction with either one of the following: force or threat of force, or the victim was unable to understand the nature of the act or give consent. And it's knowing consent is what the statute says, knowing consent. Let's switch gears and talk about false imprisonment. False imprisonment is a civil matter and is subject to a claim for damages. The criminal version is referred to as unlawful restraint. So you can sue somebody for false imprisonment. The criminal version is unlawful restraint. And under 720 ILCS 5/10-3, a person commits unlawful restraint when he or she knowingly, without legal authority, detains another person. Crime can be broken down in the following elements for a better understanding. The detention, unlawful restraint it must involve some sort of intentional detention. You cannot commit the crime of unlawful restraint by accident. You must intend for your actions to confine someone else. However, there's no requirement that the victim be physically placed in a holding area, a secure building, a cell, locked in somewhere. Rather, it's enough that the victim believes they are restrained from leaving an area for a detention to occur. For this reason, detention can result from verbal orders, lies, physical restraint. Violence or the threat of violence is often involved to keep somebody within a place that they possibly could physically escape from. So not chained up, locked away in a place where nobody can find them, all the television drama kind of things. It has to be unlawful. Those with the legal authority to detain another cannot be convicted of unlawful restraint. The court will, however, be the ultimate decider as to whether or not you had the legal authority to detain another. So this becomes a slippery slope in private security at a store sort of situation or with the police. But other than those circumstances, it's probably unlawful, right? Time is an element. There's no minimum time required that a person must be confined. Accordingly, even momentary confinement could be sufficient to form a conviction for unlawful arrest. So it could be a few minutes, hours, days. Let's talk about consent. If the victim consents to the confinement, you cannot unlawfully confine them. For instance, if a mall security officer asks someone to follow them to the security area, they didn't commit unlawful restraint if the person accompanying them did so voluntarily. And then the last element, escape. The confinement of the victim must be complete, meaning that the victim must not be able to leave. For instance, a person who can leave a confined area by opening the door and walking away is not confined. However, the victim must be aware of the reasonable manner within which he or she can escape. And the victim has to be capable of acting upon that means of escape. If the victim believes that violence will result if he or she attempts to leave, that's enough to make the confinement complete, even if there was an easy escape route. Now, unlawful restraint is a Class 4 felony offense punishable by 1 to 3 years in prison and a fine up to $25,000. The defendant will also have 1 year of mandatory supervised release, formerly known as parole, for up to 30 months. Now, that's different than kidnapping under Illinois law. A person's guilty of kidnapping under Illinois law if he or she knowingly confines another person against their will and moves that person. So you confine the person and moves that person by force or threat from one place to another. So it has to be a confinement and movement. Now, kidnapping may not always happen through some sort of physical force. A person can be kidnapped through fraud, through deceit, or enticement. as long as the perpetrator intended to secretly confine them against their will. We see several types of kidnapping, and we categorize them: parental kidnapping, the Amber Alerts that you'll see. That's a parent who doesn't have the right to take that child to or at all, or maybe during the time frame or out of a particular geographic area. Acquaintance kidnapping, they know their kidnapper. Stranger kidnapping, you don't know the kidnapper. Sexual predators. Human trafficking is a form of kidnapping. And kidnapping for extortion or ransom. So that wraps up our crimes against the person: sexual assault, false imprisonment, and kidnapping. As we move to week 6, we're going to get into property crimes and talk about burglary, arson, theft, robbery, and receiving stolen goods. We have one more week of material after that before your final. So things are going to move quick this second half of the semester. As I've urged you, keep your energy up, keep your focus up, schedule time to get in the course. As the summer heats up, don't get distracted. Finish the course strong. The things you learn in this course, you can take to CRJ 230, CRJ 227, to your internships, to your next stop education-wise, to your jobs for some of you. I appreciate your efforts through the first 5 weeks. If you need me, you know where to find me.